I'm Dina, and this is Dina's Docket. Let's break down the stunning news that the Supreme Court plans to overturn Roe, the case affirming a woman's constitutional right to choose whether or not to have an abortion. For one, the Supreme Court has come out and said, yes, this opinion is authentic. So what does this mean? It means that once this opinion becomes final, any state and the federal government may pass laws infringing on the woman's right to choose. The federal government may ban abortions in the United States of America, and a woman will no longer have recourse. The reason why this is so stunning in terms of a legal point of view is that the Supreme Court very rarely overturns their own precedent, especially in a case like this, where Roe was decided almost 50 years ago, and it was affirmed in the 90s by Casey v. Planned Parenthood. The fact that this has been settled law for such a long time is what's making legal scholars very disturbed, because there's other very important rights in our right to privacy interpretation under the Supreme Court that are now also at risk. This includes a right to use contraceptives, the right to choose who to marry. Whether or not these rights are now also on fragile territory seems to be the case, one, by reading this draft opinion, and two, with the understanding that if the court is so willing to overturn such settled law and decide that the right to privacy is no longer a constitutional right with respect to abortion, they may very well conclude that with respect to what we now consider other fundamental rights.